And right now, supported decision-making is certainly a buzzword in our system. You see it a lot of places, but it's hard to really nail down exactly what is it, what does it mean, what is it replacing, what's new about it. And so I find there's a lot of confusion, a lot of misunderstanding that exists about supported decision-making. So let's start by just talking about what is it. So supported decision-making is not new. It's something that's been around for a long, long time. It's just using the support of someone else while making a decision. Supported decision-making in the context of individuals with developmental disabilities is a process by which we're trying to support that individual, whether it's within guardianship, whether it's outside of guardianship, so that as they make decisions, they have the support necessary to make those decisions as successful as they can be. So supported decision-making, the example I like to use is a few weeks ago, I was leaving my office, it was late at night one night, and it was dark outside, and I got in my car, it's a Honda Accord, and I turned it on, and every light in the dashboard came on. The check engine light, the check tire pressure light, the check oil light, every single thing. I mean, it looked like a Christmas tree on my dashboard with all the lights that came on. And I spent my whole childhood trying to ignore my dad as he tried very hard to teach me about cars. And I regret that now, and I knew absolutely nothing about what to do in this situation. I didn't know whether to just park, and I didn't know what to do. So I got on my phone and I called the one person I know that I'm very close with that knows a lot about cars. And I'm always embarrassed to say this when I'm out, hanging out with my guy friends, but that's my wife. My wife is an engineer. She's a mechanical engineer. She knows a ton about cars. She worked at Honda for 22 years designing cars. And so she laughed at me and told me, just drive it home. It's fine. There's probably a bad fuse. And so I drove it home. She looked at it. She spent $10 at AutoZone, got a fuse, and sure enough, that was it. And it was fixed. That is a great example of what supported decision-making actually is. It's you need help with a situation, and so you pick up a phone, you call a friend that understands the situation, and they guide you through how to get through that scenario. Like I said, supported decision-making is not something that's new. But what is new is a lot of states, I think we're now up to 24 states, have passed laws officially recognizing supported decision-making both inside and outside of guardianship. So one thing I think that's very important to clear up, supported decision-making, sometimes you'll hear it posed as an alternative to guardianship, and it can be, but in Ohio, what's intended is that supported decision-making is a concept that plays out both inside and outside of guardianship. It's not necessarily adverse to guardianship in any way, shape, or form. And so Ohio has a bill now pending. It's Senate Bill 214. It's working its way through the state legislative process, and it would officially recognize supported decision-making in the state of Ohio. Now, how would that look? Or what would that look like for different people in different situations? Well, take a family like mine, for example. So I have 3 daughters. My oldest daughter has Down syndrome. That's how I got into this field. And so she's currently 15. So we haven't crossed her turning 18 threshold yet, but we will here in a few years. And we'll have to go through the analysis of how do we best support her with decision-making as an adult. What path are we going to take? And as I meet with clients, I often say there's 3 paths you can go. There's the do-nothing approach. And as an attorney, I'm not a fan of the do-nothing approach. I know a lot of families do it, and I meet with families all the time who tell me about their child with a developmental disability who's 45 years old, that they've never done guardianship for, that they've never had a legal document of any type for, and it just makes me wonder how in the world have you gotten to this point? But it works phenomenally well. From a legal standpoint, I can't explain it, but I meet those families all the time. And so there's the do-nothing approach. Now, I'm not a fan of the do-nothing approach because I find it works very well until something goes wrong. And when something goes wrong, it goes really wrong. And while some families get away with the do-nothing approach, at least while some parents get away with the do-nothing approach, I find that it completely breaks down for the siblings or for whatever support system comes along after the parents. At that point, it really goes off the rails if you don't have some kind of decision-making support structure in place. So then there's the middle ground, which is what I call structured supported decision-making. Structured supported decision-making is where the individual is still responsible for his or her decisions, but they're going to sign a series of legal documents that give their identified support system both access to information and the ability to make decisions when they can't. Now, with structured supported decision making, the individual is still the legal decision maker. And so structured supported decision making is certainly not for everyone. Every family has to analyze this on a very person-specific, case-by-case basis for what's best to support your loved one. But with structured supported decision making, the person signing a series of legal documents that give them access to information and the ability to make decisions when their loved one cannot make decisions. And then the third ground is guardianship. And guardianship is certainly still a viable option in the state of Ohio. A lot of my practice works in the field of guardianship. I represent an agency that most of you have probably never heard of or don't want to hear of, which is Advocacy and Protective Services Incorporated. And they do guardianship all across the state for thousands of individuals. And so I am a big proponent of guardianship when it's the right tool. There are a lot of families and a lot of situations where absolutely they need guardianship. Now within guardianship, they changed the laws a few years ago. And when they changed the laws, they did so because they wanted to make sure that guardians were not getting involved in every single little decision, but rather getting involved in the decisions that actually need someone else to intervene. And by doing so, they somewhat incorporated supported decision making into guardianship as well. We're basically saying, as guardians, we want to make sure we make all the decisions that impact someone's health and safety, but not necessarily the day-to-day decisions we don't have to make for them if they're capable of making those on their own. So you've got families getting closer to that 18th birthday. You've got 3 routes to go. You've got the do-nothing approach, which I don't recommend, the structured supported decision-making, and then guardianship. Supported decision-making affects, again, all 3 of those areas. Now, where does all this come from? There's been a nationwide push for supported decision-making. So I'm going to ask a question. How many people in the room remember the radio DJ Casey Kasem?
Oh, yeah.
All right. That's where all this comes from. So it certainly started before Casey Kasem, but it is his family that is the biggest proponent of this. Casey Kasem was married something like 6 times. And he had children from multiple relationships and multiple marriages. And in the last 2 years of Casey Kasem's life, his children from one of his first marriages were completely shut out of his life. And they were shut out of his life by an agent acting pursuant to a power of attorney. He basically just said in Illinois, you can't visit, and said to the facility, don't let these children visit. And those children were completely separated for Casey from the last 2 years. They filed actions in court, and what they found was an agent acting pursuant to a power of attorney had a lot of broad authority to make those type of decisions, and there's not a lot of ways to have a court intervene. And if you want to know the truth, Ohio's laws are very similar. Acting under a power of attorney, you could do something very similarly in Ohio if you wanted to. After his passing, the family connected with some legislators in the state of Illinois, and they introduced a law to stop that from happening again, to limit the power of one person to have access over another person. And so that law has been introduced in multiple different states now, and it has spun off many, many different versions of supported decision-making statutes and other statutes designed to help us have some checks and balances on limitations to visitation and things of that nature. So, in the context of guardians, how many people in the room are currently the guardian for someone? All right. So in the context of guardians, this is how it affects you. And this is a law that's already in effect. This is not the supported decision-making bill, but this is a law that's already in effect. As a result of the Casey Kasem bill that has spread across the state, they have brought that bill to the state of Ohio now 3 different times and introduced it 3 different times, and it has been defeated in Ohio all 3 times. And the reason it's been defeated is the probate judges are adamantly against it. And I don't blame the probate judges for being adamantly against it, because it gives the probate judges all kinds of responsibility for deciding visitation disputes and things of that nature with no additional funding to do that. And so probate judges don't want everyone who's mad at a sibling for how they're handling mom and dad's visitation coming into the probate court and clogging up the courts. And so the Ohio Supreme Court changed its rules last summer, and they changed the rules as it pertains to guardians. So one thing that would be different about guardianship if you were establishing it today versus when you established it is that now if you're establishing guardianship for someone, at the time of establishing the guardianship, you have to let the court investigator know and the judge know if there's anyone who wants to have visitation with the person under guardianship, but you're not allowing that visitation to occur. So if there's someone that you are saying, I'm guardian for Johnny, and I don't think it's in Johnny's best interest to see his sister because she's going through a rough patch of life and on drugs, and it's a bad scenario and it's bad for everyone's mental health, and you're establishing guardianship, I have an obligation to tell the court investigator about that. And then I have an obligation to have that be part of the conversation at the guardianship appointment here. For guardianships that are currently in effect, if you're the guardian for someone and you have individuals that you are restricting access for, you have an obligation to tell the probate judge. Now, admittedly, this is a brand new rule, and most probate judges don't have formal procedures in place for this yet. But I can tell you the probate judges get together twice a year at annual conferences. They have a conference coming up in June, and this is one of their agenda items. What are they supposed to do now as probate judges to deal with visitation restrictions? So over the next year, you're going to hear more and more information. If you are the guardian for someone and you are restricting someone else's access to that person, you will have a duty to fill out a form and provide a list of those names of people restricted to the probate court. That's not to say that the court's going to immediately set a hearing and have you come in and tell them why, but the court's going to want to know some basic rationale for that decision. And I can also tell you there is a committee working on a standardized form that families could fill out and submit to the probate court to accomplish that. So, that's one of the new things going on with guardianship. Now, let's step back to supported decision-making. So, with supported decision-making, it plays out inside or outside of guardianship. Outside of guardianship, one of the things to remember with supported decision-making, and this is one of the things that's often lost, is in situations where we're relying upon supported decision-making, the person is the decision-maker. And so outside of guardianship, a lot of times what we see is families will come in and say, okay, my loved one's turning 18. I don't necessarily want to pursue guardianship. Okay, that's fair enough. Can we have them sign power of attorneys or other legal documents? So then we have to have an analysis of can they sign other documents? And that gets into a little bit of a tricky situation. To sign legal documents like a power of attorney, a healthcare power of attorney, things like that, the legal standard is you have to have capacity. And so you have to understand what the document accomplishes. So a lot of times parents will come in and maybe their loved one has that capacity to sign that document. They will sign that document. And then the parent leaves and they think, okay, now I get to make all of this person's decisions because they signed a power of attorney. And that's not how power of attorneys work. Hopefully, a lot of the people in this room have signed power of attorneys. I'm a big believer that everyone who's 18 years old or older who can should sign a power of attorney. And again, it hinges on whether or not you can. But if you can, you should sign a power of attorney. I've certainly signed a power of attorney, and I've given my wife the authority to be my agent. I'm sure there's a joke to be made about what I'm about to say, but that doesn't mean she gets to make all of my decisions. She does, but that doesn't mean she gets to legally make all of my decisions. I haven't officially surrendered any of my decision-making responsibilities to her. Same thing with a healthcare power of attorney. A lot of people sign healthcare power of attorneys, and then the moms and dads think, okay, I don't need guardianship. I have this power of attorney, so I can go make all of Johnny's medical decisions. That's not how a power of attorney works in the state of Ohio. So for healthcare power of attorneys, when you sign a healthcare power of attorney, again, I've signed a healthcare power of attorney. My wife doesn't have the legal authority to make any of my medical decisions. The only person who can make a medical decision for someone who has capacity to do so in the state of Ohio is that person. So if I go into a doctor's office, a doctor can't treat me without permission. And to give permission requires me to give consent, informed consent. And informed consent in Ohio requires capacity, meaning do I understand what I'm being asked to give informed consent for? The person who decides whether I do or don't have the capacity to make my own medical decision is the treating doctor. It's the doctor's responsibility, it's the healthcare provider's responsibility to assess, do I understand and do I have the capacity to make the decision the doctor needs me to make? And if I don't, that triggers the authority in the healthcare power of attorney. So for families that are choosing to go the route of structured supported decision-making where they have the power of attorneys and privacy waivers and other documents in place, that's great and that's very important. But it's very important to know that means you're there as a support system for the individual. And you have access to information and you have a seat at the table as they are making the decision. And you can get involved when they run into decisions that they are not able to make. But it does not give you the authority to come in and make decisions on their behalf. And so That's one area where I see a lot of confusion by families. It's just what is the extent of authority and what is the extent of decision-making authority for families in the context of structured supportive decision-making. And then with guardianship, obviously as guardians, there has been a legal change in the decision-maker. As a guardian, you are the legal decision-maker for the individual. Now, I know sometimes the DD system, it feels like they try to water down or dilute some of the authority that a guardian might have in different situations. And I'll talk more about that in a second. But from a decision-making standpoint, as a guardian, even as a guardian, it's your job to make all decisions the individual needs assistance with. You certainly have an obligation to make all decisions that involve health and safety. And then thereafter, once you get outside the realm of health and safety, if Carol and Dustin are sitting at the ice cream counter and Dustin says, I want chocolate, and Carol says, no, I don't want you to have chocolate, I want you to have vanilla. If that's for no other arbitrary reason than Carol's in a defiant mood and wants to argue with Dustin, that's Carol breaching her duties as a guardian. She's not there to tell him what flavor of ice cream to eat because that's not a health and safety issue. Now, obviously, if there's an allergy, if there's some bigger decision involved, then it's different. But guardians are not supposed to be making the day-to-day decisions that the person can make safely for themselves. Any questions so far? I feel like I've been talking really fast. I don't have PowerPoint to keep me on track. Your hand went up first.
I was in POA, and I'm also a provider, and I saw things that I couldn't be both. So I do it.
Okay. So, POA and provider is okay. You can do both. Guardian and provider, there are rules that prevent you from being... Are you the guardian?
No, I was guardian.
Okay. If you're guardian and provider, that is a conflict of interest that has to be approved and waived by the probate court. And proof of the same has to be shown to the DD system as part of the licensure process. So, yeah, so someone up here said it's easy. So let me throw out some caveats. I representing APSI, I get to go to all 88 counties of Ohio, and I say this joke all the time. It's like going to all 88 countries of Ohio, because they're all very, very different when it comes to guardianship. In most counties, it is very easy. In a few counties, it is extremely difficult and stressful.
We ended up getting him because his mom lost him, he found out. I don't remember the county, but it's in Lake County. And we ended up finding out, so we went to Bird Farm, and we ended up bringing everything just wanting to take it for a summer and see how good and everything. But we have guardianship that way because his mom lost him. I guess he was a state ward or something at the time.
So he is an adult?
Yes.
Okay, and you have so you have letters to the Lake County Probate Court? Okay, so you're a guardian, and so...
But I gave that up because I sent them a letter because you got to redo it and pay the fee and everything every year. And I told them, I said, I'm not being a provider and guardian. So I think they just made him the guardian.
Okay.
I'm not 100% sure, but I think.
Okay, so Lake County, it's a very good probate court. Judge Bartolotta, very good guy. You would still have to get approval for the same reason of the joke I made earlier. Having your spouse be the guardian while one of the other spouse is the provider is the same conflict of interest, and in some households, maybe even a bigger conflict of interest.
Well, with us, I do all the thinking about the doctors and all the appointments and everything, and I don't get the chance. It's like now, they don't want to talk to me anymore because I'm not the guardian. And I'm like, well, you don't know what I'm supposed to ask. You don't know, you don't know really anything about the medications. You give them the medications, but you don't know that we need refills and need this and try a new medication that might work for him and stuff. And then I signed him up for Humana. Now if I want to talk to Humana, I gotta get a piece of paper saying that I can talk to him.
So, yeah, communication gets tricky. And so if your husband is the guardian, a couple things there. One, he would need to get that conflict waived by the Lake County Probate Court. Two, in terms of using you as a provider, there's a lot of misunderstanding sometimes. Guardians are responsible for consent. Consent does not mean they have to be present for every situation.
Yeah.
So if for my daughter with Down syndrome, let's say she's an adult and I'm her guardian and my wife's the provider, and my daughter's got some pretty complicated health issues and my wife knows them inside and out and I certainly do not. I get the high level stuff and don't even understand that most days. So if my wife's the one that's there at the doctor's appointment with her, that's okay. I, as the guardian, can give consent. Now, to make healthcare providers comfortable, I may have to put that consent in writing, and I will have to repeat that consent over and over. But I can give consent for them to pursue treatment along the course of action approved by my wife. I just have to verbalize that and sometimes put it in writing to the healthcare providers. So you will have a never-ending stream of saying, let me call my husband and have him tell you it's okay. There's no way around that. But unless you become the guardian. And honestly, I'm a big fan of co-guardianship. I think co-guardianship is a great way to have succession planning in place, and it prevents some of the problems. In your case, it didn't alleviate the need of having to go to the court to get the conflict of interest approved by having you resign as guardian.
Now, if we wanted to go to supported decision-making, would we be able to have the judge sign off on that?
So to go to structured supported decision-making, it means you would have to go to the Lake County Probate Court. You'd have to get a new statement of expert evaluation saying your loved one does not need a guardian. You'd have to have the guardianship terminated.
No, that won't.
Okay.
Because he can't pay for himself.
Okay.
He's not vertical either.
So at that point, I think guardianship's where you'd want to be. I think she was next.
And two questions, please. First of all, is there a difference between power of attorney and healthcare power of attorney? You referenced both.
Yep. Okay, so Ohio recognizes what's called a general durable power of attorney, and you'll see lots of different names. And the name at the top of the document doesn't really matter. But in Ohio, there's two categories of power of attorneys. There's healthcare power of attorneys that have its own set of statutes. And then there's general durable power of attorneys, which is everything else. So basically, healthcare is clearly defined as medical care. And then general durable power of attorneys are all other types of authority. So when we're preparing documents for families, we prepare a whole host of documents, but in the realm of power of attorneys, we have healthcare power of attorney. Now, in the state of Ohio, there is a standardized healthcare power of attorney form. You can get it for free off the internet. It's a very good form. It's exactly what we use. I tell every client when they come in to sign documents, we prepared all these documents in this binder except this one. This is the free one you can get off the internet. I think it's a big mistake for any attorney to use anything other than that free document. And so the healthcare power of attorney, you can get that for free off the internet, and it's the one where you're going to initial several boxes, things of that nature, and sign at the end. That document, by law, as is all healthcare power of attorneys, are springing, meaning the agent has no authority to do anything in that document until a doctor decides that the principal, the person who signed it, can't do it for themselves. So you've got healthcare power of attorneys always springing, no conditions. So even if I have the ability to make my own healthcare decisions, but I'm just lazy and I don't want to, I can't just say, Katie, that's my wife, well, you go tell the doctor what I should and shouldn't do and just have them give you a prescription and all that stuff. I can give her a HIPAA waiver and she can go talk to the doctor about how lazy I am, but she can't go and decide with the doctor a treatment plan and consent to the treatment plan and then have me be on it. That can't happen unless the doctor gets informed consent directly from me, or the doctor decides I don't have capacity to give informed consent. The general durable power of attorney can be springing or immediately effective. So when I say immediately effective on that, so for a general durable power of attorney that pertains to things like finances, things like that, we always coach families that you're going to have the individual as the decision maker and you're there as the backup support. But a financial power of attorney can be made immediately effective. So I've signed a financial power of attorney, also called a general durable power of attorney. Those terms are used interchangeably. And so I like to joke, my wife and I, we forge each other's names all the time. I have no hesitation to forge her name, and I know she forges mine, and I'm happier that she does. So legally, though, I've given her the authority to sign my name. Now, I'm sure there's certain instances where we're supposed to disclose that we're forging each other's names. You're not filming this, are you? You are?
Yeah, you're on Facebook.
Oh, okay. I didn't mean that. With the power of attorney, you're basically saying who has authority to act on your behalf. And so, using my lazy example, you see this a lot of times in the context of the elderly. So if my parents are getting up in age and they're in their 80s and late 80s, and this was true of my grandmother, when she was in her late 80s, she still had capacity most days but she certainly wasn't getting in a car and driving to the bank. She would much rather, my mom was an only child, or was an only child, and so she would much rather my mom just go to the bank and deposit her check. And my mom could do that with her power of attorney, even though my grandmother had capacity to do it for herself. So Ohio has two different categories of power of attorneys. Now, there's lots of other areas that are gray areas. In Ohio, you'll see things like education power of attorneys. We use those a lot with school systems. There is nothing in Ohio law that says you can have an education power of attorney. It's nowhere in Ohio Revised Code. There's nothing in Ohio law that says you can't have an education power of attorney. And it certainly fits, arguably, within the definition of the general durable power of attorney. So we'll often have clients sign an education power of attorney, but I wouldn't, if a school systems lawyer said, you made that up, that doesn't actually exist under Ohio Revised Code, I certainly wouldn't call him a liar, because we did. And a lot of other attorneys have too. There's nothing in Ohio law that specifically says you can have an education power of attorney where someone else acts on your behalf for education purposes. Now, there are lots of Ohio laws that pertain to in educational settings. If I'm receiving special education, I have the authority to say, I want mom and dad included in my IEP meeting. I want mom and dad to have access to my records. I can bring people into my services, but there's nothing that specifically says I can delegate decisions for my services to this person.
So then my second question is just kind of going back to the very basics. Do you, for the structured supported decision making, is that something that you then have to pay? Like, I know guardianship, you have to pay an attorney to help with that process. Is it the same with the supported decision making?
It's not the same. So with guardianship, when it comes to guardianship, some counties like to tell people that everybody needs an attorney to establish guardianship. If you're doing guardianship for someone with a developmental disability, it's guardianship of the person only. And I tell everyone that calls us to hire us to do guardianship work, you absolutely don't have to have an attorney for guardianship of the person. If you hire an attorney, you're hiring them for the convenience of knowing what to file, when to file it, but you're not hiring them to come into court and make some great oral argument that wins the day. I mean, that's not what you need. So you're paying some amount of money for the convenience of some expert to come in and show you exactly what to do and to get you started off on the right foot. But it's certainly a project that a lot of families do on their own without attorneys, and do it very successfully on their own without attorneys. So with the structured supported decision making, what we do is we have the individual sign a series of documents. I think most families would struggle to find all the documents and get them put together the way I think they should. Now, when I say the way I think they should, that's my arrogance as an attorney saying, this is how I think it should be to put you in the best light. That doesn't mean there aren't other ways of doing it. But if you told me, Derek, what's the best set of documents to have for structured supported decision making, I think it'd be hard for parents to piece together all the different privacy laws. There's a lot of, Ohio has a common law right to privacy. You've got FERPA, HIPAA, all these other privacy laws, and it's hard to hit it just right. And even when we do it, we have people that sometimes argue with clients about the documents and things of that nature. So I'll never claim to be perfect, even though I think we're pretty good at it. I think you'd have a hard time getting all of those together. I think you can get the main ones. The healthcare power of attorney, like I said, you can get for free off the internet. There is a statutory financial power of attorney in the state of Ohio. I don't like that one at all, because I think there's all kinds of problems with it, especially if you're using it for someone with a developmental disability. So I'm not going to say there aren't, obviously with the internet being what it is, you can't go online and find forms and have them sign it, and that is definitely better than nothing. But I do think it's worth paying an attorney a couple $100 to do the, a more thorough set of documents if you're relying upon the structured supported decision making. Yes?
I'm a cheerleader, and I'm also clergy, and I mean to move around a lot. So what I've been running into is that my guardianship was in Franklin County, and I moved to Fairfield County and then Pickaway County. When we moved to Pickaway County, they wanted me to move my guardianship to Pickaway County, even though the judge didn't have a problem with it. And they're saying, well, it's got to be within the county you live in. And is it county by county, or is it the state of Ohio? Who has the authority when it? Because I don't want that every time I move, it's 6 months or a year or 2 years. Because I've been to Pickaway and then back, and you don't want to just redo your guardianship every, 6 months because you have to move around or something. So what is you get my question,
Yep.
I guess.
All right, so guardianship is always based on the residency of the person under guardianship. So the person under guardianship's residency determines where you file. Once you establish guardianship, any court can transfer.
Good to see you. We've been on the road 5 days, so we're going to head out.
All right.
All right, thank you guys.
Yeah.
Bye, Dave.
Thanks, Eric.
No problem. See you, Dave. Once guardianship is established, any probate court can transfer a guardianship to any other probate court if the residency changes. Any guardian can ask for a guardianship to be transferred to a different court. So, two things, keep in mind, and there's different rules for transfers within Ohio and transfers out of Ohio. So as long as you're staying inside the state of Ohio, what you run into, especially in counties like Franklin, Cuyahoga, Hamilton, is they are the dumping grounds of guardianships. So a lot of individuals that don't have family members, they get guardians, get transferred into one of those counties because there's more providers available, there's more resources available. Those counties are very sensitive to that. And when you have guardianship cases, the probate courts have to do a report every year to the Ohio Supreme Court. And in that Ohio Supreme Court, they have to say how many guardianship cases they have, how many are the guardianship reports filed on time, how many are delinquent. And so what you find is every 2 to 3 years, a clerk in one of the probate judges, or every probate judge does this, every 2 or 3 years, it occurs to him, man, look at all these guardianship reports. Look how many people have moved out of county, because they don't actually track it in real time. We should go through and purge all the ones that have moved out of the county and transfer them to those other counties. And so in the eyes of the probate court, all they're doing is they would look at it as, well, we're not hurting this family at all because the guardianship remains in effect. There's no disruption to the guardianship. We're just transferring it from one county to another. It makes it easier for our reporting to the Supreme Court, and it's one less person we have to chase if you don't turn your guardianship report in on time. So in the eyes of the court, it's no big deal. In the eyes of the family, though, it can be a real pain in the neck because some counties, when a guardianship gets transferred, they require you to file a whole new application packet with all those forms. They want new background checks. They want all kinds of things. And so it can be a headache. Some counties ask for additional filing fees. Now, here's one thing to remember. If your loved one's in the DD system and they're on Medicaid, they're on SSI, these are means-tested benefits. If they're on those benefits, they qualify for what's called indigent status. So they shouldn't be paying court costs in any court. You should file what's called an affidavit of indigency. And so with that affidavit of indigency, that should cause the court to waive all future court costs and filing fees associated. So even when they transfer, there should be no cost to the person transferring. Now, if there's a related special needs trust under the court, and that's not very often, that's few and far between. But if you fall in that category, then you have bigger headaches in terms of transfers. But courts can transfer it or a guardian can transfer it. So if I were living down here in Hamilton County and my whole family were moving to Lake County, then I would probably want it transferred because I'd much rather have my filings every year due there in Lake County than back down here in Hamilton County. So I could send a letter to the court saying, hey, please transfer this to Lake County, and they happily will. If I don't do that, once I turn in my guardianship report 2 or 3 times and it has a Lake County address, they're going to transfer it on their own sooner or later.
But I'm all right saying that, because actually the clerk, I didn't talk to the judge, but the clerk said he doesn't mind paying attention to the counties that are adjacent to, so just leave it be. It was agencies saying no, it was the board, the county board saying.
They have no say in it, you can tell.
They have no say, okay.
They might like to tell you they can do that, but they have.
Sure, since I keep moving, and
Yep.
it just goes, it's okay.
Yeah. I think she was next.
Yeah, a couple questions. You said you have a POA. Okay, if a husband and wife and say one's in an accident, can't speak for themselves, is that automatic that goes to the husband or the wife, or do they have to have a POA?
So the question is, if husband and wife, one of them's in an accident, do they have to have a POA or does it automatically go to the husband and wife? If there is a life or death emergency, so in Ohio, when it comes to health care, first of all, there's implied consent. So if I fall over right now, hopefully I don't, and have a heart attack, I have what's called implied consent, meaning if any of you rush up and do CPR, or if a first responder comes in and they need a shock or something like that, it is implied that I would like to live. And because it's life or death and it's an emergency, it is implied that I want any or all of you or any first responder to do anything they can to save my life. So first, there's implied consent. Once a next of kin is identified, so once I am, first responders don't have to stop and look for next of kin, but once I'm in the hospital, so they put me on the cart, they take me to the hospital, and the hospital is trying to figure out, okay, did he have a heart attack, a stroke, what's going on here, let's get him into surgery. If they know my wife is standing there and she is my next of kin and they have to make a decision, then my wife, as my known next of kin who's standing there, can make that life or death decision for me.
Without paperwork.
Without paperwork.
My son was in a major car accident. He's running around here somewhere. He was 19. They told me they couldn't give me any information without getting emergency guardianship.
The minute it changes from life or death, so the minute it becomes non-imminent life or death,
he's being wheeled into brain surgery.
The next of kin lose the authority to make decisions. And at that point, you have to go get emergency guardianship. Or, if the hospital thinks that there is time for emergency guardianship, they can make you go get emergency guardianship.
They gave him 30% chance of surviving.
Yeah, and I don't know. That
yeah, I'm just saying. Challenge. I mean, that was 2007, but yeah, I had to get emergency guardianship.
That's why I'm a big believer that everyone who's 18 years old or older who can should sign power of attorneys, because we're all one car accident away from being in a bad place and needing somebody else to make our medical decisions.
Can you clarify? I work for a school district where my income level is very low for my family, so oftentimes it's the financial burden of trying to obtain guardianship. When you were talking about the affidavit of, say the word,
Indigency.
Thank you. Did you say DD, SSI, and Medicaid, or just DD and?
Any of those. So Medicaid, SSI, all those are means-tested programs, meaning you got to keep your asset levels below $2,000, income of the individual below a certain threshold, depending on which benefit we're talking about. By virtue of being eligible for Medicaid and Medicaid waiver services, you're eligible for indigency status. Now, you won't find the affidavit of indigency on probate court websites. And that is one of the areas where I think like good attorneys make a difference, because they know those little nuances of how to do that. But you absolutely should get one.
So this is something that a family could ask for?
You can call the court and ask for an indigency affidavit, complete it, fill it out, turn it in, and you should be declared, or the person under guardianship should be declared indigent. I'm going to go back there to the back next.
I have a question about this part of decision-making and guardianship.
Okay.
So we have guardianship of a person for our son. He's 23. But every time we have our Ohio ISP meeting every year, which is coming up, they want me to have like power of attorney for money management, because they want to put an outcome for money management, so a personal funds rule outcome in there. And I don't want that in there because, for one, it's a lot more paperwork. And I want to educate him about money. I don't want to take that away from him. So we do online banking. I tell him when he pays his rent, he helps me push the button every month. So he knows where his money's going. He knows how much money's in his account. He knows that he can't have over $2,000 for Social Security. So the only way we help him with his money is I'm authorized rep, because they can only be, we have dual guardianship, but only one person can be authorized rep through Social Security, because I don't want him to have to deal with the Social Security, because that's a difficult thing.
Yeah, so that is a great question. So let me try to tackle that. There are two types of guardianship in Ohio. There's guardianship of the person and guardianship of the estate. Guardianship of the estate is defined as managing assets and litigation. So if you ever need to sue someone, you would need guardianship of the estate. Guardianship of the person is everything else. And so if you have a loved one with a developmental disability and you're guardian of the person and estate, meaning guardian of both, you're making a mistake. You only want and need guardianship of the person. And here's why. With guardianship of the estate, there's a lot more reporting requirements. You've got to keep receipts. There's a lot of headaches that come with guardianship of the estate. But here's the catch. Guardianship of the estate in Ohio, you don't need it unless your assets are in excess of $25,000. And so again, by virtue of being eligible for Medicaid and Medicaid-related services, you're staying ineligible for guardianship of the estate. By establishing a guardianship of the person, you're creating a presumption that they can't sign a power of attorney for finances. And so it would be inappropriate for a person who has a guardian of their person to sign a power of attorney for their finances, unless you go to the probate court, specifically ask them to approve it, which most courts don't like it when you do that. And so when it comes to managing finances of people who have a guardian of the person, that's a great example of where, like it or not, you're going to use natural supported decision making. You're going to be their rep payee, you're going to be their authorized representative with a stable account, you're going to maybe help them sign their name as a co-signer on a checking account or something of that nature, but you're not going to necessarily have a legal document that says, here's how or why I get to manage their finances, which again have to stay below $2,000 to keep them eligible for all these benefits. It's not enough money to get the court's attention to give you guardianship. The guardianship of the person prevents you from doing the power of attorney, and so you're in that realm of being a natural supported decision making. I think in that scenario, I understand why the county board would want that, but I think it would be inappropriate for you to have your son sign a financial power of attorney.
I have a 38-year-old son. We've been guardians since he turned 18. Guardian of the person, but there is a Medicaid payback trust with some money in it of his. He's a beneficiary of it. We've never touched it. The court knows it exists. We filed, and he has a stable account now. So he has assets greater than $25,000, and the courts, one of the people, there was a question when I filed the last guardian's report of kind of hinting you're only the guardian of the person, not of the estate. So, am I,
Okay, so the special needs trust, first of all, let me clarify. A special needs trust is a trust designed to hold assets that belong to the person with the developmental disability. So I always tell clients, when you hear me say,
this with CF,
Community Fund Management Foundation. Okay. So when you hear me say trust, just picture a basket. You sign a trust agreement, you sign all this legal jargon, all you're doing is creating a basket. A first party special needs trust, it is rare that you need or want one of those. So for families trying to plan inheritance, that's not what you want, a special needs trust. So in this situation, that's money that would have belonged to your son by reason of a settlement, a back payment of Social Security.
It was an irrevocable trust created by his grandparents
Okay.
to pay
So
college expenses.
So I don't mean this being insulting, but bad estate planning. So
Yeah.
bad estate planning led to this trust.
Yeah.
That trust is always kind of like a black cloud, because when your son passes, the money in that trust is going right back to the state of Ohio. And so as a trustee of that trust, you are now a fund manager for the state of Ohio. You're managing their money. And that bothers clients sometimes, because you'd much rather see that money be used to improve the life of your son. So the first thing I would say is I would encourage you to go spend the money. Now with a special needs trust, there's all kinds of limitations and restrictions on what you can use that money for. That trust, though, is not under the jurisdiction of the court. That's an alternative to guardianship. So that money in that trust does not count towards the $25,000 threshold. Money in the stable account would count towards the $25,000 threshold. So if he's got $26,000 in a stable account, then that would justify guardian of the estate. I still wouldn't go pursue one. Now here's where it gets tricky. The special needs trust, there's all kinds of restrictions on what that money can and can't be used for. But one of the things it can be used for is it can deposit money into a stable account. A stable account is also a fund that goes back to the state of Ohio upon the person's death, but only after payment of funeral and burial. And a stable account can be used to pay for anything other than alcohol and gambling. So what you would want to be doing is regularly transferring money from the special needs trust to the stable account, and then find a reason to use it. If you're ever paying for bedroom furniture, airfare, travel expenses, They now have cruises specifically for people with developmental disabilities. So transfer it into a stable account. Everybody looks at Carol. Transfer it into the stable account and take your son and go on a cruise. All you're doing is reducing what's otherwise paid to the state of Ohio. It is very frustrating for families on death when you write a check for money back to the state of Ohio. I'd much rather see you funnel that through the stable account, because then that sheds a lot of those rules and restrictions, and then use it to improve your son's life. So over here was next. Yeah.
I have two things.
Okay.
One, and I'll just piggyback my first one there. The special needs trust, so now I'm just totally confused. So I have got a special needs trust, funding it with life insurance on me that trust is the beneficiary. So there's no money in the trust. So, but I don't understand what you were saying about special needs.
Okay, so let me stop you on that one, and I'll answer.
Can I get the correct again?
Yeah.
We have two special needs trusts, actually. One is this Medicaid payback trust that had his money. We put money that was his in there, and that's why the state would eventually get that. We have another one set up, also with community funding, as part of a prior estate plan. There's nothing in it, it's not funded, but we can, as part of the estate plan, put money in that. You're doing that with life insurance to help him after we pass, if it's necessary. Okay. Money that goes in there, my understanding is when my son dies, we can specify what happens to that money when he dies, because it doesn't go to the state, because it was never his money in the first place. So it could pass to his brother or somebody like that.
Yeah.
So there are multiple flavors of special needs trust.
Well, you said a lot of accurate information with one big exception.
Okay, hold on.
The terminology. So let me stop. The system draws a big line between assets that belong to your son and assets that belong to anyone else.
Right.
When you create a trust that holds assets that belong to the person with the developmental disability, that by law is a special needs trust. Now, a lot of attorneys, a lot of third parties, they slap the title special needs trust on the top of any trust that benefits a person with a developmental disability. And that is a mistake. Now, the name does not matter. Ultimately, the name at the top does not matter. It's what the body of the instrument says that matters. So, like with Community Fund, you only have one special needs trust. You have a special needs trust, and then you did their joinder agreement to their discretionary trust. A discretionary trust is the name of the trust that holds assets that belong to anyone else. So I suspect if I read your documents, what I would hope for you is I would find that you have a discretionary trust designed to hold assets that belong to third parties, and someone's just put the title special needs trust on the top of it. It's one of my pet peeves, but that doesn't itself cause problems, but it does cause confusion, because that trust, when it's funded, is going to be reviewed by Social Security, Jobs and Family Services, the Department of Medicaid, and the County Board of Developmental Disabilities. And they are all trained that with special needs trust, here's the rules they have to comply with. And with discretionary trust, here's the rules they have to comply with. And so you inevitably, especially in the Chicago Social Security office, you're going to have somebody trying to apply the wrong rules to the wrong type of trust. It doesn't mean that the trust is going to be treated improperly. It means somebody's going to have to answer more letters and explanations, and it just leads to confusion and delay. So a discretionary trust is the name of a trust that holds assets that belong to mom, dad, or any third party. A special needs trust is specifically for the person with the developmental disability, and those are always subject to Medicaid payback. A discretionary trust, just like he said, he was exactly right. When his son dies, his discretionary trust through Community Fund can go to his other kids or grandkids or wherever he dictates.
Next, my other
Yep.
question. Okay, authorized draft. So, since I'm the guardian of my daughter, of the person, the county told me that they could handle like
So what you want to do is get one of the JFS forms. There's a JFS authorized representative form. You're going to fill it out. You're going to sign it, appointing yourself as the authorized representative, and you attach a copy of your letter of guardianship. They don't actually have the authority to, well, you are, by virtue of being a guardian, an authorized representative for state systems. So if we're talking about the different state systems, your letter of guardianship is your access to that information. The county board actually has no say in it. I mean, they may like for you to go through them, and it sounds like they were doing some good things, but they don't have the authority to exclude you or include you. You as the guardian are actually the gatekeeper for who gets access to that information. So there's a little bit of,
Can it be both?
it can be both, but there's a little bit of an inverse power system here where you're looking at them as though they get to decide who acts, and that's where you kind of need to take back, it's you that decide. You have the letter of guardianship. You need to contact JFS in writing with your letter of guardianship and assert your power. It's you that controls whether they get the information, not them that controls whether you get the information.
So like this is an example. So someone stole my daughter's food card, EBT card, and they, it was stuck up in DODD. So I had to report. This was recent. And everyone kept telling me, oh, call this person, call that person, and they wouldn't talk to me. So it was, I guess, that office that had to do with EBT. And the county was like, call them and tell them this.
When you call, you're going to have to keep sending in your letter of guardianship. I mean, they're going to need that letter of guardianship to be able to communicate with you. But you have the ticket for who has access to information at the state level. Yes.
Okay, so I'm a fiduciary for my child, okay? He has a trust that's called a Medicaid payback trust.
That is a special needs trust.
Okay, that's what I thought. So once that gets drained, I hate to use that word, then I can file for that indigent whatever you were talking about?
So it depends on what county you're in. Some
Portage.
counties count the corpus or the principle of a special needs trust when determining indigency status. Others do not. I don't know Portage's rule.
Okay, does the stable account count towards that?
Towards indigent status?
Yeah.
Most counties do count that, yes.
Okay, then he'll never be able to qualify. That was my question.
The stable account, you said that if at their passing, where does that money go if it's in their stable account?
So stable account also goes back to the state of Ohio. Now the difference is with a special needs trust, when someone dies, it immediately goes back to the state of Ohio. No pass and go, no paying for funeral, nothing. It goes back to the state of Ohio. With a stable account, it gets paid into the person's estate, where you are authorized to pay for all the funeral and burial costs. So clients will often ask me, how much is too much to have in a stable account? And I say, until you get up above 10 to 15 grand, you're not really risking anything, because you could easily spend 10 or 15 grand on a funeral and burial this day and age. So that's kind of the buffer. When I meet with clients, I met with one last week that had $86,000 in a stable account. It just made my heart cringe, because all of that money came from mom and dad, and they had no idea that this money was going back to the state of Ohio. And I had to tell them, just like I've told other people, you're now a fund manager for the state of Ohio. You are now, because their child's 42, and stable accounts are great for what they're used for, and special needs trusts are great for what they're used for. But they do create this black cloud effect, where you feel like, I need to spend it, or else someday I'm going to pay it back to the state of Ohio. And I'll tell you, when people pass away, there's an attorney at the Attorney General's office. He's a good friend of mine. His name is Bob Byrne. He can tell you to the penny how much money the state of Ohio has spent on your loved one's behalf. They track every single provider service, every single Medicaid expenditure. And what's deceptive is a lot of people think, well, I have Medicaid, but I don't use it. Well, it's like any other type of insurance. Every month that you have Medicaid, the state of Ohio pays itself a premium for that coverage. So even though you're not using Medicaid, you've got a monthly premium being moved from one pocket of the state to another, and they count that towards your Medicaid payback. So I see payback numbers. I had a person pass away recently. He was profoundly injured when he was 19 years old, and he died at the age of 29. And he needed 24/7 assistance from age 19 to age 29. And the family had, $2.1 million left in a special needs trust, and they thought some of that money was going to come back to them. And we emailed Bob, and I was trying to set their expectations, because I just met the family after he passed away. and I was trying to set reasonable expectations, their Medicaid payback amount was $4.4 million. And so now the family has no liability for the overage, none at all. But that $2.1 million was gone. Now, to their credit, Bob Byrne, who runs the Medicaid payback, or in cases like that, and it's hard to call this a generosity, but the state of Ohio would call it a generosity, is he will usually say the state of Ohio will waive payback for, like in that case they did $100,000. So the family could have $100,000 of the money. Now this family thought they were about to hit, I don't want to paint them in the wrong light. They were devastated their son died. But they thought a sizable amount of money would be coming back to them, not $100,000. And it was a pretty rude awakening. And then they're sitting there thinking, well, I wish we'd known this 10 years ago. We would have done more trips and bought a boat and sailed around with them or something. And it's hard.
So on the stable account though, because we were looking to establish one for my daughter, she's 21. She can withdraw from that at any time and
Yep.
use it for anything.
Anything except alcohol and gambling. You can get a debit card, and as long as you're not doing a bender in Vegas, you're fine.
Carol,
She
stay
can
on.
go to Vegas.
Stay on.
She can go to
you know.
Vegas. Yeah.
I have,
Sure.
me?
Yep.
I have two things. So, Derek is my son's attorney. And we do have a stable and special needs trust. And as he said, we're in the process, we haven't done it yet, of doing that very thing, filtering money through to a stable account, because we have discovered cruises. My son is in heaven on a cruise. All the music, all the people, the food, the laughter, he loves it. So he's 39, and we're going to enjoy life. He has had enough crap, so he is going to enjoy life. My other question, and now I know who you are, I know Michelle Bean. I know her from Facebook.
Yeah.
The other question is, in the supportive decision making, I have guardianship over Dustin because I know he can't sign papers, but where do you draw the line? I've talked to some people who their children are nonverbal, not real expressive, but they want to choose supportive decision making because they think guardianship is too restrictive. So where's that line get drawn?
Okay, so where I say it gets drawn, and this is my opinion, and I've done a lot of research on this, the statute for who can sign these documents. What it actually says is any person with sound mind can sign one of these documents. I hate the term sound mind. The term sound mind is not defined anywhere in Ohio law. When you have a term that's not defined anywhere in Ohio law, that means it's up to the judges and the judiciary to tell us what it means. Every judge or magistrate that's ever been asked to interpret what that term means says it means capacity. Capacity means the ability to make a specific decision. So the example I always use, and I've done a lot of research and a lot of teaching on this, is you look at the individual supported decision-making documents. So the first one that we have people sign is a HIPAA waiver. Now, how many people in this room have signed a HIPAA waiver? All right, how many people in this room have read a HIPAA waiver from start to finish? In this crowd, there's probably a few. Yeah.
Got two.
All right, I haven't. I do this stuff for a living. I would never, ever read a HIPAA waiver from start to finish. But I sign them all the time. And I don't really care what they say. I mean, I know it pertains to medical records and who gets to talk to my doctors and things of that nature. A lot of times, in the name of protecting people, we hold individuals with a developmental disability to a higher unfair standard. People walk in doctors' offices every day, they're handed the clipboard, they fill it out, they sign the HIPAA waiver, they hand it back. No one stops and says, Mary, did you actually read that? Let's talk about what these terms mean. Do you understand what 42 USC and this wherefore, now, thereto, all these weird words us attorneys use? Nobody ever does that. And so with people with developmental disabilities, we often say, well, hold on, I don't think you understand and you can't sign this. Now, it's hard to draw the line in the right place. What I tell clients when they're coming in for supported decision-making documents is, and I mean this, I could care less if they've ever read the document. But I care very, very much that they understand what the document accomplishes. So that's why we prepare the documents, we send them to the families weeks in advance with some notes and instructions. And you take somebody like my daughter with Down syndrome. If I take her into a strange law office and hand her a HIPAA waiver that's 3 pages long, Am I going to be able to convince everyone else sitting at the conference room table that she understands it? Probably not. If you give that to my wife and I a couple weeks in advance, my daughter loves to read. She'll read every word of it. And then if we talk to her about, okay, do you understand that this means mom and dad can talk to your doctors? Mom and dad can talk to your dentist? Because that's what a HIPAA waiver is. It's just saying who you can talk to. She would understand the concept behind the document. And so what matters from a legal standpoint, we're all responsible for what we sign when we're adults. As the person notarizing the document, what I care about is, does the individual understand and have a good understanding of what the document accomplishes? I don't care if they've read it. I don't care if they understand all the weird words. Can they communicate in whatever format they communicate that they understand the concepts behind what the document's accomplishing? And that is a fine line. And it has been very uncomfortable at times where I've had to tell families, I'm sorry, I can't notarize this. And there's other times where, I mean, for every time that I have to tell somebody, I'm sorry, I know you drove in here from Licking County or wherever, but I can't notarize this form. I'm not sure your loved one understands the document. That's hard. I also have hearings where I'm establishing guardianship for someone and I meet the person at the guardianship hearing and I think, why in the world are you pursuing guardianship for this person? They could have signed these documents. So there's errors made on both ends, and anyone that tells you they know exactly where the line should be drawn is lying. I tell families, when you're trying to figure out how to support your loved one with decision making, get a lot of different opinions and don't give too much weight to any one opinion. So ask attorneys, but don't think attorneys are experts, because they spend 0 days in law school learning how to assess people's decision-making capacity. I'm on a task force with the Ohio Supreme Court, and we've been meeting with the Ohio Bar Association and a series of doctors. And I can tell you, there's a lot of really smart doctors. You get 10 of them in the room, and you'll have 10 widely different opinions on what it means to need a guardian versus sign a power of attorney. They don't know what the standards are. They have no idea. And I don't mean that as an insult, but they don't spend any time in medical school researching that. You talk to teachers, and they're trying to give good advice, but they're basing it on what they've seen other families do, and they don't get training in school for who does and doesn't need. So I tell families, get everyone's opinion, but don't give too much weight to any one person's opinion. You've got to decide what you think is best for your family in terms of supporting decision making.
Okay, thank you.
All right, we'll do one more.
So I'm with my daughter's guardian, and basically there was a little argument of whether she needed one or not, but it came down to the fact that she's just like, I don't want to do this. I don't want to talk to these people. Actually the judge in the order said that to her the world is so frightening that trying to make these decisions, and that's the reason why, and he reviews it periodically to see if that's changed. And she's my only child. I have no other family. So my concern is would she be better in supportive decision making, so when I pass away and she's out there trying to navigate the world, that someone can't take over, because it's going to be a stranger. We don't have family to be her power of attorney. They're going to, I guess, case management will find some legal firm that does it. So would it be better to kind of guide her towards that, so she would have more protection for herself as she ages and I will be around to help her?
So I never like to say what someone else should do without meeting the person, having a lot more information. But I will tell you the challenge you face is the same with or without guardianship. It's who is going to be the support system for the individual. And so whether it's finding someone to take over as guardian or finding someone to take over as agent and support system, either way, it's trying to develop that natural support system. And that is hard. We run into families all the time that struggle with it. It's very hard. So, if you want to write this down, my email address, if you have questions, is my name. It's I meant to bring a stack of cards, and they're still sitting on my desk in Columbus. It's Derek, DEREK, and then it's pglawOhio.com, and that's all one word. PG Paul George Law LAW Ohio.com, and then my phone number is 614-397-0740.
How far do you travel to give talks?
I go all over the state. All right. Thank you all very much.
Thank you.